And welcome to another edition of Legal Pepper Soup, the show where we like to dish up and serve deliciously hot pieces of legal information, news and advice. I am your host, Obi Wakeji. Now, in employment law, we'll take a look at settlement agreements and when they're used as a means of terminating employment. If you're an employee and you've been offered one, what do you need to look out for? Or, if you're an employer, what do you need to do to make sure that the agreement satisfies the requirements so you can be protected from possible future claims? Now, before we start, I have to issue a warning. Please do not rely on anything you hear on this show as an alternative to legal advice from your solicitor or other professional legal services provider. Don't delay seeking legal advice. Don't disregard legal advice. Don't start or end any legal action because of anything you have heard on this show. So if you go to court and things go wrong for you, you can't say, oh, I heard it on Legal Pepper Soup. It's nothing to do with us. If you have any specific queries, please use the contact details below. And I'll also read them out at the end of the show. Now, Lawrence, settlement agreements, I think you need to put the microphone to your face. What is a settlement agreement?
Right. Basically, settlement agreement is the agreement entered into by the employer and the employee to set out the terms upon which the post-employment relationship is governed. Because of course, during the course of employment, you have or you should have the employment contract to say this is the basis upon which we have this employment relationship. But at the end or after the employment is finished, what happens? Because you have settlement agreements in use in most cases in two scenarios: in the case of redundancy, or where there has been a dispute between the employer and the employee. And of course, before the employer lets the employee go, they want to make sure that we put things in place to ensure that the break up or the breakdown of the employment relationship, the times for that are set in stone. There's not going to be any problem after this employer has left us. So that is the main purpose for settlement agreement.
So essentially, the employer wants to make sure that the employee leaves the organization without having to come back again to bring any matters of dispute. It's sort of like a clean break.
That's right. Okay, say for example now, this employee feels that he might have a case of unfair dismissal or constructive dismissal or discrimination or any such claims under the Equality Act 2010. The dispute has been going on in the workplace, and the employer feels, why don't we just reach some form of agreement here? You go your way, we go our way, but before we do that, let's make sure that terms are put in place so that once you go, you're not going to come back 1 year later, 2 years later to take illegal action against us. And again, in the case of redundancy as well, employers always want to make sure that once we pay you off, in an exchange for you to compromise some of your position and your rights as well. So while the employee is gaining something on the one hand, on the other hand is actually giving away some right. So before you enter into such agreement, they want to make sure that terms are put in place so that everybody is clear on their position before the end of the employment relationship.
Is it always wise, say for example an employee, is it always wise to enter into a settlement agreement? Say for example in a case where you have a significant dispute with your employer, you have good proof or you have good evidence to establish what you are alleging. Is it always advisable to settle at that stage rather than taking the case to court? I mean, what would you...
Yeah, it really depends on the terms of the settlement agreement. If I feel that the terms are generous, they're reasonable, they're proportionate, then of course I will be advising, and I always advise my client that, look, it is better for you to consider the terms of the settlement agreement and accept the terms, again, if I consider them to be generous, because you might feel that you have a strong case to go to the tribunal, but one needs to bear in mind that litigation is a risk. And of course, you have to consider the time, the resources, and the cost of taking any legal action against your employer as well. So once and if the terms of the settlement agreement are fair, reasonable, proportionate, and all of those things, then of course it is always for me better to take settlement agreement instead of considering or proceeding with a legal action against your employer.
What happens in a position where the terms of the settlement agreement are plainly unfair?
Well, in cases like that, now employers have a duty to advise you to go and seek and obtain independent legal advice before you sign the settlement agreement. So if you go to your own solicitor, they will advise you about the unfairness or the whatever is wrong with the settlement agreement. So they should be telling you, no, do not enter into this agreement, don't sign this agreement. And of course, you have a choice not to sign the agreement. If you are not happy with it, then you can continue with your tribunal claim if there is one, or you can start one if you haven't started one already.
All right, so let me just revisit what you've just said there. What happens in a position or in a case where, say, for example, the employee hasn't actually voiced out his concerns or hasn't actually made his case against his employer, but is given a settlement agreement, and obviously he takes independent legal advice? My understanding of settlement agreements are that the obligations on the lawyer, I think, are specifically to advise the employee that once he has signed that agreement, most actions he can take in court are over.
Yes.
So essentially, he can't say in a year's time, "Oh, I didn't know I could sue for this and I can sue for that." So I think that's one of the main reasons why they seek independent legal advice. Now, is there an obligation on the lawyer to advise the client in relation to any possible claims he might have had against the employer? If you put it in the position where the employer has simply brought a settlement agreement for the lawyer to advise on the terms of the contract, is there an obligation on the lawyer to then advise the employee about his employment and as to whether there are any possible claims he could make?
Well, in fact, the main reason for the legal requirement to obtain independent legal advice before you sign that settlement agreement is really because once you sign it, you are in a way signing away your rights to sue. Now that's qualified in a way, but let's just put it plainly, that's what it is. So the employer will say, we will pay you for you to give us an assurance that whatever claim you have against us now is become settled. And if you're thinking of bringing a claim in the future, that claim is also become settled now. And even if you don't have any idea that you might have a claim against us, maybe 2 or 3 years down the line, you find out something that happened or which you did not know about, you now want to start a claim against us later on in the future, you will not be able, or you might not be able to bring such a claim. So it is the duty of the solicitor to advise the employee to put it to the person that, look, once you sign this agreement, you may not be able to sue your employer in the future. But that's all well and good. But as far as the employer is concerned, that's what they're actually paying you for. I'll come across situations whereby people feel that I want to sue the employer. And then they might actually have a good case against the employer. But you look at the situation in this way: if you sue your employer, how much are you really going to get in terms of damages or compensation? Maybe £20,000, but your employer is actually paying you off £15,000 now. So whatever you feel like, if you feel, okay, I'm going to sue you for what? To get monetary compensation. That's what it's all about in most cases, but that's what they're paying you for. So you might as well take that settlement agreement with the provision of the compensation, that's been offered, instead of, considering taking legal action against the employer, maybe now or even later on in the future. Of course, there are always times in the settlement agreement, as long as they did not cause any disadvantage to you, then I think it makes sense to say, I'm not going to sue you once you pay me. That's the whole point of settlement agreement. In fact, in the past, it used to be called compromise agreement, because you are doing it with the understanding that you are compromising your rights, you are compromising your legal position. So as long as you get paid for that, then why not? Because the whole point of, again, taking legal action is so you can get paid. But they pay you now, then you're not going to be needing any legal action later on then.
So what do you think an employer should have in a settlement agreement to make sure that it is binding?
Well, there are three things that any employer needs to be aware of as far as settlement agreement is concerned. The first is it must be in writing. The second is it must set out very clearly the claims that are being compromised by the employee. In fact, say for example, if you see 10 pages settlement agreement, 3-4 pages is usually dedicated to the very, very long list of claims that you can never bring in your life against your employer. So you have to set it out very clearly. There is an exception to that in relation to personal injury. It is not possible for anybody to exclude liability for personal injury. But in any other case, you can exclude almost every possible claim that is there. So that's the second one. And the third one is the requirement for you to advise the employee to seek independent legal advice of his own. So that means they cannot use your in-house legal department to advise them on the terms of the settlement agreement. Those are the key three things to make sure that the settlement agreement is valid.
You mentioned personal injury. So personal injury claims are not covered by settlement agreement?
It's not covered by settlement agreement. So you can exclude any other claims in the settlement agreement, but in the case of personal injury, you cannot exclude liability for it. Again, it is qualified in a way whereby in most of the settlement agreement, you will see something that says provided, or yes, all these claims are excluded, but personal injury is not excluded, provided that you are not aware of it at the time of entering into this settlement agreement. So there's always a provision to it, but by and large, generally, liability for personal injury cannot be excluded.
All right, let me throw out a scenario here. So say, for example, I'm at work and I've injured myself at work and I have already started my personal injury claim against my employer.
Yeah.
Now, are you saying that my employer can't put my personal injury claim in that settlement if my employer has offered me a certain amount in relation to that as well?
Well, you can reach settlement agreement in relation to your existing personal injury claim. So you can say, let's reach settlement agreement. We pay you off. Our employment relationship comes to an end. You go your way, we go our way. All well and good. But what you cannot do or say is to prevent you from bringing a personal injury claim in the future. Say, for example, okay, we're paying you this much. Our employment relationship is now come to an end, and in the settlement agreement, we are also making a provision saying that once you leave your employment, you cannot sue us for personal injury. That is what the settlement agreement cannot do. It can be used to provide for full and final settlement of any existing personal injury claim, but it cannot be used to prevent possibility of the employee to bring a personal injury claim in the future.
All right. So the monies that are provided. So normally, an employer will offer an employee a certain amount of money.
Yes.
Usually, it's called, I think, a lump sum payment.
Usually.
Is that subject to tax?
Now, in the case of redundancy, any redundancy payment that is less than £30,000 is not subject to tax or national insurance contributions. But anything more than that, the excess of that £30,000 is subject to the normal tax and NI contributions. But one is to be careful with that. It only relates to the redundancy payment. So any other payments, for example, payment in lieu of notice, your holiday pay, any other benefits or payments that you might be entitled to, commission and bonuses, those ones, they're still subject to the normal tax and NI contributions. Now, sometimes I see different wording in settlement agreement. They call it severance payment. Usually, that one is also not subject to tax and NI contributions, as long as it does not have the appearance of your normal pay, your normal salary, your normal wages, then that one is not subject to tax and NI. But if it appears to suggest that this is what this looks like your normal wages that you would have got, you would have received had your employment continued, then that one could be subject to tax or NI contribution. But that's one of the things that we look for very carefully in any settlement agreement, to make sure that what are your tax liabilities. So whenever we advise employees about that, you'll be looking to that to say, is there any provision relating to tax liability? And if there are any provisions, you have to make sure that those provisions are correct as to what which payment is subject to tax and which one is not subject to tax. Yeah, and if you find that anything suggests that you should be paying tax on any payments that you shouldn't be paying tax on, we bring it to the attention of the employer. You review it and then you correct wherever needs to be corrected.
Is this one of the areas that an employee seeking advice on the settlement agreement should seek from his lawyer?
Yeah.
In relation to whether or not tax is payable.
Yes. In fact, well, different people, different way of doing these things. But for me, the first thing that I look into is the money bit, right? The money bit. How much are they paying you? You need to look into the fairness or the reasonableness of the amount that's been paid. For example, you take a lot of factors into account. The length of your service there, your weekly or monthly wages, your age as well. So you consider different kind of factors. And I also consider your chances of finding a job, your chances of being reemployed. How good are your chances of finding another employment after the end of your employment that's finishing now? So you look into that and say, what I've been offered is it good enough for me? Because you need to think about, once I leave this job, when will I get another job? Whatever is being offered now, is it going to last me for 2-3 months? So that's the first thing that I always consider, the money that's been offered. And after that, you go into any deductions. What is being deducted from that? Is it subject to tax? Should it be subject to tax? And then how will that apply to maybe this particular payment and other payments that might be mentioned in the settlement agreement? So yeah, that's the first thing for any employee to be aware of.
As you said, is that the money bit?
The money bit. The money bit.
And that certainly puts out or specifies exactly whether or not the whole offer is actually fair.
Yeah.
Are there any other points that you would like to mention in relation to a settlement agreement that I haven't asked you right now?
Yes. Most people always negotiate for reference as well. So you should bear in mind the need to negotiate for reference, accurate, standard, correct reference. And also you need to be careful about restrictive covenant. Some of these agreements, they contain restrictions, even though your employment is come to an end, but they still make reference to what you can do or what you cannot do. In most cases, what you still cannot do after the end of employment. So you need to look into that and make sure that if there are such provisions in the settlement agreement, again, they are necessary, reasonable, and proportionate. If you consider that they are not, then of course you should be arguing that they should be removed from the settlement agreement. If they have to remain there, make sure that they're necessary. Yeah.
Right, thank you for that. So that's it from the Legal Pepper Soup podcast. Thank you all for listening, because without you, the listener, there is no podcast. Now remember, please drop us a comment to let us know if you like the show, what we could do to improve, or what you would like us to do or discuss in future episodes. You can find us on Facebook. You need to search Legal Pepper Soup, on Twitter at Legal Pepper Soup, or visit our website /blog legalpeppersoup.com. If you would like any specific legal advice on any matters discussed on this show or in general, please email info@ojnsolicitors.com quoting Legal Pepper Soup, or you can call the numbers on the screen quoting Legal Pepper Soup. I am Obi Wokeji signing out, and remember, ignorance of the law is no excuse.